Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition, we're talking about domestic violence cases, and in particular, the unreported case of SJS versus RJD. In domestic violence cases, they use the initials. And in this case, a final restraining order was granted where a married guy kept contacting his ex-girlfriend, who was his girlfriend while he was married. So the defendant here appealed the trial court's entry of a final restraining order pursuant to the Prevention of Domestic Violence Act. The plaintiff ended a long-term dating relationship with the defendant after learning the defendant was married. Kind of interesting that she didn't know the guy was married while they were dating. So the defendant began a campaign of attempting to contact plaintiff, including sending her thousands of text messages from 49 different phone numbers. Defendant also followed plaintiff where she was in her car, blocked her car in the parking lot at her workplace, threatened to post provocative photos of her online if she did not communicate with him, and telephoned plaintiff at her personal and work phones, filling up her voicemail. The defendant denied some of the alleged contacts and faulted plaintiff for not responding to his thousands of text messages. The trial court found plaintiff had proven the predicate act of harassment and had established the necessity for a final restraining order. The defendant appealed to the appellate division. The appellate court affirmed. Plaintiff's evidence demonstrated that she never responded to defendant's efforts to contact her after the final breakup, which countered defendant's assertion they were simply repeating an old pattern which she always got back together with him. The defendant's message threatened to continue to contact plaintiff repeatedly and stressing her until she got what she wanted, supported the trial court's finding of defendant's requisite intent of harassment under the Prevention of Domestic Violence Act. The defendant argued the FRO in this particular case wasn't necessary because it was merely meant to make him stop bothering plaintiff, but the court admonished that sending thousands of unwanted texts from 49 different numbers was harassment under the act, not mere bothering, as the trial court correctly found. Plaintiff's testimony, the substance and relentless nature of defendant's communications, and undisputed evidence that it took a temporary restraining order to make defendant stop his harassment all supported the trial court's finding that an FRO was necessary to protect plaintiff from immediate harm or further acts of abuse. And that's the case of SJS versus RJD. For other information on domestic violence cases, visit website njlaws.com. And for representation, contact Kenneth Vercammen's office in Edison at 732-572-0500. Thank you. Have a great day.